The talk intends to look at seven particular points. First of all, by way of an introduction, to give a context to litigated housing conditions claims, before going on to consider some of the more important topics under the pre-action protocol. It will then look at how to plead and defend cases on the pleadings. Fourthly, look at the very important topic of allocation of housing conditions claims, before looking finally at trial preparation. There will be a separate topic looking at the Homes Fitness for Human Habitation Act, and in particular the impact it's recently had on mould and damp cases, before coming to a conclusion. The law, practice and procedure is as stated in March 2023. All is not lost for tenants, even if the court allocates the claims the small claims track. The case in that respect is the well-known case of Birmingham City Council and Lee, a 2018 case in the Court of Appeal. What the court held in that case, that notwithstanding that the claims allocate to the small claims track, the court retains a power to award fast-track costs to tenant solicitors up to the date that the works were completed, if the tenant then succeeds at trial on the small claims track. The rationale behind that was, if the claim upon being advanced under the pre-action protocol and up into the works being done was otherwise a fast-track claim, then the tenant solicitor should be awarded the fast-track costs up to that point in time. Before I look a little closer at what that test may mean, there are, of course, exceptions and defences so far as landlords are concerned. It's the first two that are of the most importance. First of all, the issue of notice. The same applies to the unfitness provisions as applies to your traditional Section 11 defences. That is to say, it is still incumbent upon a tenant to prove that the landlord had notice, whether actual notice or constructive notice, of the defect or defects giving rise to the unfitness allegations. And it's only when the landlord, upon being given notice, has failed to remedy the unfitness, can a landlord be liable for the same.